the year when they have the fiscal looking at for at least the 2024.
They're going to change.
Good evening. We are going to call the May regular meeting of the Verona Zoning Board of Adjustment to order at 8:05 p.m. Madam Secretary, would you please read the notice of this meeting and call the roll?
The notice requirements of the Open Public Meetings Act have been satisfied with respect to this meeting of the Township of Verona Zoning Board of Adjustment, which is being held in person in the ballroom of the Verona Community Center, located at 880 Bloomfield Avenue, Verona. The time and date of this meeting were included in the annual meeting notice posted in the community center and sent to the official newspapers of the township, the Verona Cedar Grove Times and the Star Ledger, at least 48 hours preceding the start time of this meeting. The agenda and instructions on how to comment will be provided at the appropriate time. All meetings are recorded. Those wishing to speak during public comment should only provide their name and municipality. Street addresses are not required. Please be advised that should a member of the public choose to state their street address, it will not be redacted from the recording. Dr. Reese. Here. Mrs. Murphy Braddix. Here. Mrs. DiBartolo. Here. Mr. Ryan. Here. Mr. Mathewson. Mr. Cortez. Vice Chair Weston.
Here.
Chairman McGinley.
Here.
Board Attorney Musera.
Here.
The engineer we have, I'm sorry.
Oh,
Your name.
it's AOVAO Alvaro Gonzalez, Chief Operating.
Okay, thank you.
Okay. Would you please stand and join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I'd like to start the meeting with some general information about this board. This board deals with the issuance of variances from the Verona zoning ordinance. That ordinance establishes specific requirements for the land area in the township and regulates not only the uses permitted, but the size of lots, setbacks required, parking, signs, conditional uses, and numerous other such regulations. An applicant is never entitled to a variance. Applicants must meet specific criteria contained in the state municipal land use law by satisfying certain legal standards of proof. The burden is on the applicants to show that they should be granted the specific relief requested. Depending on the type of variance requested, applicants will need to prove special reasons, undue hardship, a balance of benefits, and other criteria. These are legal proceedings. Public meeting notices have been published. Neighbors have been notified. Applicants and their representatives will provide sworn testimony and be subject to cross-examination. Any action this board takes at this meeting will be memorialized in a resolution document prepared by our legal counsel that will be reviewed and adopted typically at our next regular meeting. At that time, any variances granted will become effective. That said, we are a board that conducts its business in a fairly informal manner. Applicants are sworn in, tell us what they want to do with their property and what they are asking the board to do. Board members will question witnesses, and then members of the public may question those witnesses. At the conclusion of the testimony, members of the public may make a statement regarding the application. After closing the public portion of the application, the board will deliberate and render a decision. First item on our agenda is the approval of minutes. We have minutes from our regular meeting of March 14th and from our regular meeting of April 11th. They were extensive. Has everyone had an opportunity to read those minutes? Okay. If you have had an opportunity to read them and are comfortable with them, I would entertain a motion to approve those minutes, either together or separately.
Mr. Chairman, I will make a motion to approve the March 14th minutes since I was at that meeting. I was not at the April meeting.
Okay, we'll do them separately. You have a second on that?
I'll second.
Okay. All in favor, please say aye.
Aye.
Any opposed? Any abstentions? One abstention, noted. Okay, takes us to the minutes of the regular meeting on April 11th.
I would like to make a motion that we accept those minutes, April the 11th.
Thank you, Doctor.
I'll second.
Thank you. We have a motion and a second. All those in favor, please say aye.
Aye.
Any opposed? Any abstentions?
One abstention.
One abstention, Mr. Ryan. Okay, the minutes are approved. That moves us to resolutions. We have two resolutions, again, extensive from those meetings. Resolution 2024-05, oh, let's start with the easy one. 2024-05, the appointment of Gregory Massara as the Board of Adjustment Attorney. For those of you who didn't know, Mr. Gassion has submitted his resignation effective April 15th. This resolution appoints Mr. Massara through the end of our regular year, June 30th, 2024. And if someone would move the resolution.
I'll move it, Mr. Chairman.
Okay, we have a motion, second.
Second.
Second. May we have a roll call vote on this one?
Dr. Reese,
Yes.
Mr. Ryan,
Yes.
Mrs. Murphy Braddix,
Yes.
Mr. Mathewson, sorry, Mrs. DiBartolo,
Yes.
Vice Chair Weston,
Yes.
Chair McGinley.
Yes. Okay. Congratulations. We're good for a few weeks.
Yeah.
Okay. That takes care of that one. Now, the two that Resolution 2024-06, Linwood Road, 97 Linwood Road, granting approval to remove the driveway and garage, construct an addition to the existing house, add a new patio, and construct a retaining wall, all with conditions.
I'll make a motion to approve Resolution 2024-06.
Okay, do we have a second?
I'll second that.
Thank you. A motion and a second. Resolutions, all those in favor, please say aye. Oh, wait, we only need the people who voted for the resolution to actually vote on the resolution. All we need is one person.
Aye.
Thank you. Okay, how about Resolution 2024-07, 45 Montrose Avenue? Construct a two-story addition on the left side of the house, new garage, master suite. That was the one that came and then downsized the deck and downsized the driveway and downsized the size of the addition. And again, it would have to be somebody who voted for the resolution. So do I have a motion and a second on the resolution? Nods, thank you. And the vote, Dr. Reese voted yes, so that moves that one off. Okay. New business. first application of the evening under new business is application 2024-02, 698, 700 Bloomfield Avenue. Counselor, I understand that we're going to have a continuance.
Thank you, Mr. Chairman. Angelo Cifelli Jr., the firm Pyrozina Cifelli Paris and Jenna Tempo for the applicant. Mr. Chairman, in light of the fact that there's only 6 members present and we require a use variance, we are asking for a continuance to the next meeting. We will waive the time period.
Thank you.
Actually, June 13th.
To June 13th. We need to make that official on the board, so if there is a motion.
I'll make the motion.
And a second.
Second.
Okay, is there any discussion on the motion? June 13th.
Members of the public, this matter is carried. The matter of the application of 698 700 Bloomfield Avenue, Block 1606, Lot 13, will be carried to June 13th. No further notice will be required of the applicant, and none will be given because the adjournment is announced at this meeting tonight. That's deemed to be sufficient notice. The applicant has waived the right for this body to act in a certain period of time. So we'll see you June 13th.
Thank you, Mr. Chairman.
Thank you, Mr.
Members of the board.
Thank you, Mrs. Spelling.
Mr. Chairman, just a point of order here. I know we've continued this on a number of occasions, and from what I understand, they want basically a full board present. Is that just for the edification of the public?
They need 7 members.
Okay.
Yes, they need 7 members. At the moment, the board only has 8 members assigned. We're waiting for the town council to assign a 9th, well, at this point, a 9th person, which would be our second alternate. The 2 alternates fill in for the 7 members of the board when they can't make it. And in a case like tonight, we had 7 members up until about 55 minutes ago. So that's kind of how this whole situation developed.
So I just didn't want anybody in the public to think that there's anything untoward going on here. So, it's just the way the law is laid out, and the applicant has the right to have the 7 members present. So hopefully in June, we'll get there. Thank you.
Okay. Well, that just made your night so much better. Okay. Now, it's going to make it a little bit more interesting for everybody, right? Had I known, I would not have come this evening. Billy Joel and I are celebrating our birthday tonight. So that's it. In any event,
Happy birthday.
thank you. In any event, we're gonna move on. Application 2024-06, 12 Linwood Road. If you'd be so kind as to remain standing, council will swear you in, and then you can have a seat and tell us what you need.
Can you state your name and address for the record, please?
Rachel Wagner, 12 Linwood Road.
Can you raise your right hand? Ms. Wagner, do you swear or affirm that the testimony you are about to give is the truth?
Yes.
Great, have a seat. Council, do we have right to hear this application?
The application has been deemed complete, notice is proper, and you are able to proceed.
Perfect. Ms. Wagner, if you would be so kind as to tell us what you'd like to do and what you need from the board.
Sure. I'm looking to put in an in-ground pool, 12 by 24 feet with a patio around it.
Excuse me, when you speak, should I press the buttons? Got it.
Should I repeat all that?
No.
Yeah.
No, you don't have to repeat it, that's just,
Okay.
That's it?
Yes.
And can you summarize what you would need from the board?
I need a variance for the side and rear yard.
Okay. Let's see if we can. Okay, according to the zoning officer, okay, swimming pool shall be located no closer than 10 feet to a side or rear yard. The proposed pool is located 6.7 feet from the side property line and 7 feet from the rear property line. So you need the variance for both of those. Swimming pool should be located 10 feet away from the principal building. Pool is located 7 feet away from the house. So you need a variance for that. Patios must be a minimum of 5 feet from property lines. Proposed patio is 4.7 feet away from the side property line. The accessory structures located in a yard, such as a pool, can have a maximum of 15% of aggregate area coverage. The proposed pool and patio have a coverage of 38.8, which exceeds the allowed limit. Okay, so I'm looking at 4, maybe 5 variances. Okay. And you have had an opportunity to read through the report from Boswell Engineering and from the Verona Environmental Commission?
Yes.
Okay. Okay, so let's get us, all the paperwork's in order. Now, if I'm reading correctly, the Verona Environmental Commission raised 2 issues. One with the overall impervious surface coverage that appears there are items that are not on the survey that we had. There appears to be a front porch, which they identify as being built after 2020, which is 180 square feet. I believe the rules for front porch in Verona are 75 square feet.
So the porch was put in, when was COVID? It was right around COVID, 2020, and I came here for an approval on a variance for the porch and got the permit. I think it was November 2020.
Okay.
What was the other item that isn't on there?
The other item that they questioned was lot coverage, and our environmental commission is fairly good at scaling off the drawings.
There's a temporary, like, one-step-up platform in the backyard that will be removed. I don't know if that's what it's picking up. It's 12, what is the measurement? 10 by 12? 10 by 12.
Okay. All right. Anybody can jump in with questions of the applicant at any point in time. I think we've got a baseline for where we're headed.
So the spot in the backyard where it looks like there's the trampoline and looks like stone underneath, that's going to be removed and it'll be grass?
Yeah, that'll be removed.
Mr. Ryder, do you have witnesses prepared for this evening?
Yes, I have 2 people with me.
I'm sorry?
Yes.
And just so for the board's edification, they might reserve some questions. Who do you anticipate calling as your witnesses?
Michael from Pool Town, the pool company.
Okay. And who else?
Do I need to?
No,
Oh,
I'm just asking.
just one.
You can do what you please, but, okay. You have anybody here to testify as to the variances and why the variances should be granted? You understand that you have a burden?
Yeah.
Okay, we're not ready yet. I just just trying to, okay.
I guess at this point, we would ask you, why would we grant those variances?
Because I really would love to put a pool in for my children so that they can enjoy it. And I'll make whatever adjustments are needed to make sure that I'm not affecting anything with drainage or my neighbors.
Mr. Chairman, I guess I'll ask the obvious question. In your current configuration, have you had any water issues with all of the rainstorms, or have any of your neighbors complained about any runoff from your property?
No, never.
Well, how deep will this pool be? You say you want your children to use it, is it just going to be for them, or is it an adult pool as well?
It would be for both. It's 6 feet.
You're covering a lot of area. Had you thought about a smaller pool?
I did consider it, but I'd really like them to be able to swim further in it, so the longer the better. I really would prefer this size.
Mrs. Wagner, I alluded before to, or actually specifically mentioned it, the applicant has the burden of proving to the board that for certain reasons the variances should be granted. And respectfully, because I want the pool is not a valid reason. It doesn't mean you can't prove valid reasons.
Okay.
Okay. But there are, without trying to go through the entire law, there are positive criteria and negative criteria. You have to prove the positive criteria, prove the negative criteria. So it has to do with the master plan, the municipal zoning code, et cetera. It is my opinion that you do not have the expertise to prove to the board what you need to prove.
Okay.
The gentleman from the pool company is also not a professional planner licensed by the state of New Jersey and can present testimony, but it will not be considered expert testimony to warrant the granting of these variances. So every applicant has the right to not withdraw the application, to ask that the matter be adjourned. And as much as I know that, summer is coming and things like that, and I don't vote for the board, but I've been doing this a very long time. I would suggest that you think about perhaps coming back with a professional that can try to justify the board's granting of these variances for you.
Okay, so what is needed for that? Because I've only been through this process once, and
Okay.
it was not this difficult.
Right, well, these are, one that was during COVID, so that was probably by Zoom. You said you
No,
did
I
your
was
porch?
here.
Okay. These are variances that, and as the chairman noted, there's at least three, and there's also an impervious coverage issue. And that, which would lead to a fourth variance, that you are increasing the impervious coverage. And the calculations, it might be that your impervious coverage exceeds what the zoning code permits. If that's the case, you will have to come up with some kind of plan for drainage, because the idea is for the water, rainwater, stormwater to go into the ground
Right.
and not run off. So there's a lot of issues, I think, that, you know, with right now, with you and only the individual from the pool, it would be my advice to the board that they have not been presented with the arguments to even consider granting your variance, that it would be premature, because there will be no testimony as to why the variances should be granted, at least pursuant to what the law requires.
Okay. Okay, so there's no opportunity for just talking through, like having him come up and talk through what adjustments could be made or what the options are?
You mean adjustments with regard to the size of the pool? Well, I mean, that would be if you didn't need any variances, you would, you know,
Maybe not the pool itself, but around it for the coverage?
well, the coverage is one of the four issues. I mean, you have no closer than 10 feet to a side or rear yard, 10 feet away from the house. Patios must be 5 feet away from the property line. And then the accessory structures can only be 15% of the aggregate coverage. So your burden is significant. And I'm not saying that you can't meet that burden, but there's certain proofs that have to be presented to show why the variances should be granted, why it would, you know, there's, why it's consistent with the master plan, why perhaps it doesn't conflict with the provisions of the zoning code. Okay, it can be done without detriment to the public good, things of that nature. So there's a litany of catchphrases, which I didn't recite word for word because for some reason they're just not coming into my head right now. I should know them like this, but without preparation for that, like I said, I can't even advise the board that you've met the minimum threshold to even vote on it.
Okay.
Mr. Chairman, if I could, you know, just follow up on what Mr. Massera said, and just to make sure that I'm thinking properly. In looking at the variances, as Mr. Massera suggested, it's not the pool itself, it's the fact that you are encroaching on the setbacks and different things like that. So follow up on what Mr. Massera said, you would like a bigger pool, but you're not giving us enough convincing evidence to say, you could still put, to me, just looking at it, you could still put a pool in and meet most of the, at least eliminate some of the variances here by just decreasing the size. Am I
That would be
thinking along the
one.
right lines here?
That would be one way.
Yeah.
Another way, applicants come in and explain that their lot is considerably undersized for the zone that they're in. And, you know, if you take every house on Linwood Road and say, look, these are all 8,000 square feet, my house is only 5, that's an argument.
An unusual
An
configuration
unusual
of your lot.
configuration.
Right.
We look for items more of the land than as the owner, because the variances we grant go with the land. So if you decided to up and move, or if your neighbor who said, go ahead, put it right up against the fence, moves and somebody else comes in, then they have to live with our decisions.
So this drawing that we have here, it's on the title block of a company called the Cannon Group. Yes. So those are engineering, planning, and surveying services. So chances are there's somebody who needs to sign off on this drawing. So I'd recommend maybe speaking to them about it.
Okay, so, I mean, is there anything you can,
You're calling me up, I can.
yeah, can he come up and answer it?
We would love that.
Okay.
Hi, guys. I'm Michael Paniotu, and I'm from Pool Town Incorporated, 5500 US Highway 9, Howell, New Jersey.
Can you please spell your last name?
Yeah, it's P as in Peter, A, N as in Nancy, A, Y, I, O, T as in Tom, O, U.
Mr. Peniatu, can you raise your right hand?
Absolutely.
Do you swear that the testimony you're about to give is the truth?
I do. So, and looking at our plans, I'm part of a team that helped develop it along with the engineering core of our group. And so here I was hoping to come in and provide some testimony, not on a PE level, but certainly with 20 years experience under my belt and working closely with engineers. I do see a bunch of different issues with the engineering plan from the naked eye. There is nothing here, as far as hardship is concerned, it is difficult to get a pool in the location that we need to with an overdig that is going to sufficiently fit in this area and also provide enough recreation space for her family to proceed with a pool. Anything else would be a literal bathtub. So when we're looking at this and we're trying to get it close to the house, we have, in order to get our smallest size pool, which is a 12 by 24 at the time that we were selling them, into her backyard in the shape that we were talking about, this was the only orientation that we felt would suffice and give enough of a barrier between the property line and the actual pool and be within reason. I also see the lot coverage issues that we have here. A couple places that are considered impervious that are located on here is on the left-hand side of the property. We have an existing walkway that's actually made of stone. And one of the things that I was reviewing with her earlier that I'm not sure of is whether or not Verona considers stone impervious. I know that there are some towns that do.
It's pervious.
It is pervious. So this is a stone wall.
Sorry, it's impervious.
It's impervious. Okay, so that's what I thought too. So when we're talking about it, this is a stone walkway that has stepping stones on it. And I know that the township, you guys require 20% of the block that you're stepping on space away to be considered impervious. So one of the things I was suggesting to them was that if we were to just remove this gravel that's here, that would help build on the lot, allow enough water to pass through. Another thing here that's on the plan is there's already significant drainage naturally because of the elevations of the yard. If you look at the back property line and the side property line, when I first went out to the house, I had actually suggested that we do retaining walls, which I don't see pictured here on this, and they would have been minimal, but that would have helped a lot with the drainage. It would have helped a lot with moving it around the actual property itself in towards the front yard and out into the street. I know that in most cases we need something to capture the water. I think a seepage tank would be overdoing it, considering when I looked into the backyard, especially considering where the existing paver patio is, there was not a lot of water buildup. There was almost nothing there. You could tell just from the way that the natural progression of water went in the backyard. It went around the house and to the front.
Did you do calculations?
We have calculations. I unfortunately do not have anything with me. I have to get an engineering report. Currently, the only thing that the engineers that we put together was the deck drain, unfortunately. And so when I saw this coming into the meeting, I knew that we would be a little bit underprepared. So if I do recommend that you postpone this so we could get better calculated drawings on here. However, I also think that I could possibly give a resolution now that might appease the board, and if I were to talk to it without necessarily having calculations on the water mass, and we could get that information to you later.
Not generally the way we work.
Okay, understood.
The calculations are important to us to move it through, because we want to make sure we're all talking about the same number of coverage. The goal is not to have any additional water that's coming off the property, so calculating what's there now and what you're going to be changing, those are important numbers to us. We want to do the best we can for the adjacent neighbors, the local storm system, etc. So it does sound like council's advice to gather together those numbers, come back You can't substantially change this particular application.
Yeah.
You can lessen the variances.
Yeah.
So if 7 feet becomes, if you move it further from, for instance, if you were to move it further from the back and side fences, if that little corner of the house is what's the 7-foot mark, that might be a discussable item as to whether or not that can be smaller or whatever.
Okay.
But this is what you need to do, is you need to come back with a handle on where you stand as far as needing variances and trying to tie them to the land.
Yeah. Yep.
In the process.
Okay. I think that's what we're going to have to do in this particular case. So if it's okay, if we postpone to next session or whenever.
What do we need to do that officially, Council?
Need to do officially is that, Ms. Wagner, you agree to carry this application to the board's June 13th meeting, is that correct?
Yes.
And you consent to allow the board sufficient time to consider your application, and that any time constraints in the municipal land use law are waived, is that correct?
Yes.
Otherwise, we'd have to vote tonight, which I don't think would be prudent. So, okay. And for members of the public, there is no further notice will be required. The applicant has made notice, and that will be sufficient for the June 13th continuance. Thank you.
Thank you very much for your time.
Just for the record, board secretary, board zoning officer, what are we looking at in June? Because we know you're going to be behind what could be a very long application.
If this is carried to June, at this point, I believe we are filled for June, maybe one over.
Okay.
My next question is, if revised items are being submitted, what is our timeline on review?
Well, the timeline, because it's a continuance of an application, technically, plans could be modified during the course of a hearing, so there is no strict 10-day requirement. But if you could have plans in, or if you have a report calculations 10 days prior to June 13th, that would be very, very helpful. So Dr. Gonzalez can review them. Everybody's trying to work with you.
Yeah.
It's just a matter of, there's certain minimum requirements that we have that we have to have proper reviews, et cetera. So if you can get everything in 10 days prior, that would be great.
I really appreciate the advice.
Thank you.
Thank you.
Okay, so. All right, that moves us to application 2024-08. Where am I? No, 2024-07, 114 Park Avenue. Okay.
Didn't know you didn't have an easel, so it's,
Hey,
I just prepared a little visual aid.
You state your name and address for the record, sir.
John Guadagnoli, architect. My address is 224 Lorraine Avenue in Montclair.
And who are you appearing on behalf of?
Mr. and Mrs. Simonides, Rose and Michael Simonides. They're the owners of the property. I'm the architect who prepared the drawings.
Could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth?
Yes.
Thank you.
Council, do we have the jurisdiction on
Yeah,
this?
we have jurisdiction, Mr. Chairman. Notice was proper. The application was deemed complete, so you may proceed.
Very good. My client, without saying their names over again, They purchased this property actually last year and discovered that some of the things they wanted to do ran into some local zoning challenges. So without belaboring it, let me just go over physically what the problem is and what they want to do about it, and then I'd like to have them come up and explain the reasons they need to do this, okay, and what the hardship would be.
Everybody has a copy of the plans, I assume, right? Okay. So this corresponds directly with the site plan that was submitted.
Sheet A1.
Yes.
And that is the application, so we don't have to mark it? That was the exact application, or should we mark that?
Mark this. This is
Okay. And
Should
can you
I
read
bring it up?
Can you read the title? No, that's fine, and then you can.
L1. It's landscape plan.
Okay, thank you.
L1.
Okay, that is not paperwork that we have?
That's correct. This is just the visual, this is just a direct copy from the site plan you have, but it's colored and enlarged, so you can sort of what you see better. It's exactly the same thing, just enlarged for your ease of viewing.
Viewing pleasure.
So, I'm going to point here that the existing house sits kind of in the middle of the property. It's a one-story house, and as it exists right now, it complies with the rear and side setbacks. However, part of the front of it is a pre-existing condition. It exceeds the front yard setback. It's over by about 3 feet. We propose to add a level onto this that would be within the zoning setback on all sides. So the big thing here is that my clients wish to install a terrace in the back, which is, that's why we're here, is a non-permitted accessory use. This is a use variance. This terrace would sit squarely in the back of the property, and it would, beneath it would be a two-car garage. In exchange for that, in a way, what they're proposing is that the existing one-car garage, which is up here where I'm pointing in the upper part of the property, be eliminated, as well as all the blacktop or asphalt that exists in front of it, as well as the portion of the driveway that goes to the street. Now, let me explain. This is kind of a shared driveway situation. There's a neighbor here who owns most of the driveway, but there's a slither that belongs to my clients. And this situation forces them to, if they want to use the garage, it forces them to essentially trespass. It's an understood shared thing, but it's just an unfortunate situation. And so what they want to do is turn this all into green again, and on the other side of the house, construct a driveway that would lead to the garage under the terrace. Where we're proposing the terrace to be, there is an existing wood deck, which is roughly, it's a little smaller than the deck we're proposing. So it's just a swap, okay? And in addition, they'll be moving a stone terrace back here, and as well as some other ancillary walks and so forth, as well as part of a little piece of the back of the house. In a nutshell, what it means is that the existing house and property exceed the impervious coverage by about 2%. The new proposed design will bring the impervious coverage into compliance. Also, this garage is too close to the property line for accessory structures, less than 2 feet. By eliminating that, we've eliminated essentially another violation of the ordinance. Also, the existing deck, because the house has exceeds the front yard setback, it's a strange thing in the ordinance, but I read it, but it is what it is. If the deck can't be higher than 4 feet above the natural grade, well, it's like 7 feet above the natural grade. So that's another problem we're eliminating. So we're eliminating a host of what would be variances if we were asking for them, and in exchange, just permit this one thing. We're reducing the impervious coverage, and we're eliminating a whole bunch of other problems with the site. Now, overall, just so you know where this property is, it's the last house on the block before you hit Verona Park. The entrance to the park is literally like 50 feet from our driveway here. That's where people go in and out. As such, this driveway and this terrace is not visible to any neighbors, other than the one that's here. So, there's nobody living behind them, there's nobody living next to them. And even this is the access to the park, so it isn't like there's a picnic area here. Everything's like far away. The bocce ball court's like 200 feet, 300 feet away. So there's nothing here that this would impact. It really doesn't, hurt anybody. Furthermore, this makes the park property look like Verona. I mean, you go down the street, it's house, driveway, house, driveway, house, driveway. In this case, you have house, driveway, driveway, house. And so by reducing the size of the driveway, it looks like all the others. And plus, we have a planting buffer now to isolate this house from the others. So it privatizes the house. And by eliminating this garage, you don't have two garages right next to each other. And the last thing I want to say, back here, this is like a lot of blacktop. It's a lot of asphalt. It doesn't look like Verona. It's a tarmac, essentially. So by cutting this off and making this all green, we really restored the property in compliance with all the others on the block. The place will look like it was always like this. Right now, this is the anomaly, So, I think that's about it. So the hardship here is really this whole access to the existing garage, and we can't even make the garage big because the ground just dramatically drops off here. The high ground is up in the front, and it slopes back toward the park. Which, by the way, this driveway also it follows the contour of the land, so that it's really only about a foot or two lower than the adjacent property. So it's not like we're digging a deep hole. We're not digging a swimming pool to get into this garage. The ground does it for us. And you just enter the garage, which is on basement level, and above it is a stone terrace. And this area of the park is completely vegetated. So again, it's very private. It's not like something anybody's going to really see. Certainly, it's no worse than the deck. Let's just say that. And I should mention that the terrace is in line with the main floor of the house. It's not higher or lower or anything. Any questions?
I have a question. Do the neighbors on the right-hand side, is there an easement? Is there currently an easement with respect to?
No, there is no legal easement. There isn't. So they could put up a fence anytime they wanted, and that's.
That wasn't part of the transaction of the purchase of the property?
Well, I'll have the homeowners come in.
There was no easement. Sir, you can't. Thank you.
I have another question. Did you take into account the turning radius of these cars around this back corner?
Yes. If I may see this terrace, I may have to shift it back or forth a tiny bit in the event. But yes, I did. We have 20 feet of space to back, and I created a little spur here so that they can do it.
So that's not on our plan here?
What is it?
That little spur, that little...
Oh, is it not?
It's not on this one.
Well, I'll certainly factor it into the coverage. I want to stay compliant with the 40%. That's how much you're allowed to cover in this zone.
Does the rear door, there's a rear door, that will go into the garage when your new plan, or is that still going to be outside?
Oh, the existing rear door from the basement? Yes, it will access the garage from the basement, yes.
So you do have the room to slide the garage if you need to?
Yes, exactly, right.
While we're on that side of the house, in the front, on that side, there's on the driveway, there's an AC unit?
Yes, over here, yes.
Right. Where will the AC unit be moved to?
Sorry, I didn't show it, sorry, back here. In the back.
Okay, in the back of the house.
Back of the house, yeah, next to the terrace.
Preferred location?
Yeah. If there are no more questions for me, I'd maybe pass them.
Just hang on. We're slow but thorough.
Okay, take your time, please.
Okay.
This site plan is showing a trench drain. Can you tell us where that goes to?
Yes, well, like I said, the ground drops off, so according to the engineer's report, we have to send that water onto our property, and it should follow the natural contour of what the ground does, especially since we're not increasing the impervious coverage, but in fact reducing it. So, it's not going to make anything worse than what it is. Currently, this driveway, the water that runs down this driveway, it will be supplanted by this water. It's the same, the same thing. The back of here is lower than the trench drain.
The Boswell report that we got with our package lists a number of items that they're concerned about. Have you had an opportunity to review their comments on your plan?
Yes, I have, yes.
Okay, do you agree with them? Do you take exception to any of the ones that are listed here?
No, they seem reasonable. I mean,
Okay, I just wanted to get that on.
Yeah. No, there is one small thing, and it's not Boswell, it's someone else. It's,
Environmental Commission?
let me see. It's the environmental, yes, that's right. There's a dispute as to what the coverage is. I
Running into a lot of that lately.
I reviewed this with the zoning, not zoning, with somebody from the zoning office, let's put it, the deputy zoning officer, and.
Could be 25 different people in the last month or so.
Yeah, she's not even there anymore.
It was Powell.
Paola's not even there anymore, right. Yeah, so I did review it with her, and then I amended it according to, because we had a difference, so I amended it the way, as that's what this is. But now the Environmental Commission claims that, we're at 40.2, and if they are right, 0.2 is easy to remove. 0.2 is, we'll stay within the 40. That's the final analysis.
The Environmental Commission has also brought up the tree.
Yes, okay. You can see this tree where I'm pointing right now. Literally, they built the steps. The previous owners built steps around the tree rather than removing it. The tree is literally a few feet from the wall of the house. It's a miracle there's no damage to the house. That tree has to go. I mean, it just has to. It's like practically on the front door. One branch falls and it's over. So this one has to go. There is another tree here, which is also rather close, but I guess my clients would testify as to what they want to do with that. Other than that, there's just like shrubs and vegetation along the side, but no major trees of any sort. And that's really the only thing that gets impacted. We're not doing anything.
So they want to take down the left-hand tree, I'm going to call it for lack of a better way.
Yeah, the one that's closest to the house, in the front door, yeah.
May I ask a question, Mr. Chairman? It was already brought up that with regard, Mr. Ryan had asked whether you had reviewed the Boswell memo and that you can comply. If I could ask Dr. Gonzalez whether these should be reviewed as the board is inclined to approve, post-approval compliance, or do you feel that there are conditions that need to be addressed?
I'm a little concerned about how stormwater is going to be managed because the driveway is sloping towards the garage. And naturally, it drains west. How do you manage to capture that and then the runoff that is produced by the driveway in that impervious area, the new impervious area?
I was going through the trench drain, I was just going to pipe it to daylight, essentially. Now, if the engineer feels that we're piping it too close to the back of the yard, which would send runoff to Verona Park, then we'd have to have some sort of, water management, like a dry well of some sort to manage it, with an overflow. But that's the way we would handle it. And by the way, there's nothing but green for as far as the eye can see, so it's not like nobody's getting flooded here. But we're simply transmitting what was flowing already the same way. I mean, we're conveying it differently, but that's what
Do
it
you
is.
have any idea as to which storm depth are you using to design this trench?
Storm depth?
Yeah, 2 inch, 3 inch storm.
Oh, the rainfall.
Yeah.
I believe it's 2 inch around here, right? If I'm not mistaken. It's a 2 inch per hour. So, oh, you mean like, in other words, is the trench drain big enough to manage?
Yeah, I mean, I don't know which storm, the design storm that you're going to use to size your trench.
Well, I won't do it. There'll be an engineer doing it.
Oh, okay.
But
He's going to provide us with the calculations.
absolutely, yes, yes, he'll do that.
Mr. Chairman, just another, I guess, clarification. I did notice that the county was notified about the proposed changes, at least it's they were, and maybe I'd ask Mr. Messera. Greg, did they still get to weigh in on this, even if we approved it? Would they still have any ability to say, we don't like the fact that the stormwater may be draining into the park, or that's?
I think they're just, as a neighbor, but not as the county.
Okay. They
So,
don't have
right.
any,
Absolutely.
okay, just wanted to clarify that, thank you.
Would it be acceptable as a condition of such an approval on the engineer's report at the page 6 of 6, based on the report, please address the above items, and then it's listed 9, 10, 11 of the items in the report. For instance, number 9 is a signed and sealed copy of survey referenced on sheet A1 should be provided to their office. As a condition of approval, I would think we could say that you would comply with the engineer's report requesting certain things.
Yeah, that's a post-construction survey they want, right? They want to make sure that we built it according to the plan, is that right?
It would be both.
There are some, that's right.
Some that are pre.
Yeah, yes, Dr. Gonzalez, there are some things that they wanted shown. For instance, associated floor plans will be provided for the rear dwelling projection removal on any proposed addition.
Oh, absolutely, yes, yes. And site details, yeah, they asked for.
But as a condition of approval,
Yes.
so no permits would be issued until Boswell signs off on it.
Yeah, I thought that's how it's always done.
Well, that's,
Yeah, yes, the answer is yes.
Okay.
it's not always done, it's always supposed to be done that way, but it's not always done.
Keyword supposed.
Right.
So I have a question. So would the review be a straight engineering review, or would this be considered a stormwater management review? Because we're doing it two different ways now.
Well, I think it would be both.
Both?
Right, I think it would be both, because there's both that are required.
Okay, so there is an additional fee, and there will be additional escrow for stormwater review.
Yeah, for the engineer, yeah.
And if you could save us some time, the engineer raised a question about the retaining wall.
Yeah, the retaining wall is, it's almost nothing. It's like, it's no higher than 18 inches. You can see on the topo, the top of the wall, I give the top of the wall height, and then I give the driveway side and the other side, there's like a 1 foot difference. There's really not much there.
It's not going to be a 4-foot retaining wall.
No, because blessedly, it follows the contour of the ground, it goes down with the ground. So we never get a situation where we're in a hole, you know. It's a natural fit. That's why we're so pleased with it. You know?
Hey, Mr. Chairman, correct me if we got into they brought up the tree removal issue, and I know the tree removal ordinance is relatively new, to the land use here. Would it be appropriate for them to, they could really just do this now, even without having a plan before the board, if they just wanted to remove the tree, correct?
Right, oh, yeah, we're not approving,
Okay.
the tree is not our jurisdiction.
That's not really in our domain. I know that's mentioned in the,
We just want to make sure that the applicants.
you're aware of
it.
the requirements.
Yep.
Okay.
Is that a separate application?
Yeah, I'm reading from that, once again, I think the report was very well written by Boswell. I'm not trying to brown nose you or anything, but I do like the fact that you specifically cited the tree removal ordinance. That's really a totally separate function from your, if your variances are approved, you still would have to apply separately for the tree removal.
So we will forward that information to you.
Please. Yeah.
Are you making provisions so that water doesn't accumulate on this porch right here that's over the garage? How,
It'll be pitched slightly, and it'll be collected in a rain gutter essentially, or else it's going to stain the building if you just let it run down.
yeah, I was there today, and I noticed that there is a patio there now, and is that pitched as well? Or are you making sure that this doesn't collect water?
The patio, you're talking about the one that's in the middle of the property back here?
No, I'm talking about the one that's in the back of the house.
The deck.
The deck is?
Okay, deck, I'm sorry. Okay. Water will run off this, I take it, you say it's pitched.
It'll run off it and toward the rear yard. Engineers said you should use the pervious parts of the land to absorb the water, to percolate, and maintain the natural runoff. Don't channel it toward the neighbors. You know, yeah, I read it carefully. Yeah. Yes, it'll be clear water.
Just so we have some stuff on the record that makes sense about the terrace, which we need to approve. If you could just talk a little bit about the terrace, how it's similar to a deck, how it's protected from the, you're going to have a railing, and just so that we have something in the record.
Very good. On your drawing, there's a 3D perspective. It's just a simple one on the submitted drawing, right in the middle of the page. There's a black and white, yeah. You can kind of see what it'll look like. Yes, it'll have railings just like any deck. Only thing is the surface won't be wood. It'll be a concrete deck with stone on it, like a blue stone or a flagstone of some sort. Yeah, and so from all appearances, it'll appear like a deck, except without the wooden trellis and all that underneath it. Also, it'll be surrounded with greenery. I mean, they're not just going to have a stucco wall there. It'll be planted and landscaped all around. So essentially, it'll just be like this, just a hovering platform.
Will there be access from the deck to the yard on the exterior?
Yes, and that access would be kind of where I pointed the air conditioning unit, because that's where the ground is highest, so you only need the fewest steps. The ground climbs up there.
Okay.
So it climbs up, so you only need a few steps to get up to it, yes.
And the access from the house is,
Right in the middle.
there'll be sliders or something?
Correct. Yeah, be sliding doors, that's right.
So between the stairs and the air conditioner condenser, that's an increase in the impervious coverage then?
Oh, okay, yeah. Yeah, I guess it would be.
I have a question related to these shrubs that I see that are on the property line next to the park. Do you know if they are the property of the applicants, or are they Essex County's?
Let me refresh my memory a little bit here.
So they're on the plan west side. So to the left of the driveway, there's a series of shrubs. You can see it in this picture here.
Oh, sorry. Those shrubs there are on not ours. They're on the park side.
Okay.
They're right on the edge. They're right on. There's no demarcation as to where the property line is, but that appears to be right on the border, right there.
So I'm just wondering how practical it is to, you're going to have to trim those things back, at least ask permission from the county to trim them, because you won't be able to drive through that, it appears.
Well, I think if they're on our property, we're allowed to trim them, aren't we?
Did he just say that?
If anything that encroaches over the line, you can trim.
Mm-hmm.
You're counting this grass strip as part of the pervious coverage? Is the grass strip in the driveway?
Yes. Yes.
You ever see a grass strip survive?
Well, even if it's dead, it drinks water.
It is.
Seagull Road. Huh? There's one on Seagull
Yeah.
Road all the way down.
Can I ask about the material? I mean, I know you said this is a simple drawing. Is this intended to show what it's going to look like? Are you changing the character of the outside of the house?
Oh, I'm sorry.
Are you changing in terms of what will this look like when it's done? Are you changing the character of the outside of the house from
the siding that's on it now? Is this all going to be
Yeah,
flat like this?
No, it'll be a different looking house, yeah.
Can I ask a question for council? So I don't know that we have seen just a single page of an application before that is just specific to the variance that's requested. I mean, this appears to be, you know, we're not reviewing the height, like there's other bulk requirements that we're not reviewing because it's not part of this application. Is that typical?
I'd like to provide a zoning chart, a zoning compliance chart.
There's no engineering plans, there's no site plan per se.
But there's also not a series of architectural drawings that has the second floor shown.
Which is not part of the variance application.
So you could do that.
Well, you can, you know, we're kind of all getting used to each other here. Okay, so normally I would see a set of architectural plans and arguably engineering plans. That's why when I asked Dr. Gonzalez about, you know, what can go later, because essentially there's going to be a site plan review after. I mean, that's essentially what's happening, is there would be a site plan review, and also they would have to submit building plans for the second floor that we're not addressing. So it's out of custom basically, but it's still acceptable. But
I guess my
if you're
point,
uncomfortable, then I think it's legitimate to say, you know, I don't want to vote on any variance because I want to see what, you know, I want to see the proposed end product. You can't reject it. You can't reject it because you don't like the aesthetics. But once they need a variance, any kind of bulk variance, the aesthetics can come into play, right? Because that's part of the bulk variance. If it's going to be too close to the property line, then what's it going to look like?
yeah, I guess that's my point to the board, is that this is going to be a bigger mass than just what is seen in these pictures.
Correct.
Right.
But as per I did provide a zoning compliance chart, and we do not exceed the height, we do not exceed, you know, we are within the envelope. And so, you know, that you can be sure of. Now, whether you like the building or not, you know, that's another matter. But had I known this would have been important, I would have been happy to. It's just that if you say no, it's a lot of wasted work.
Absolutely.
You know what I mean? It really is, and that's why we kind of bifurcated this thing.
Yep.
You know.
Which the site, we're not giving site plan approval. Right, so, you know, this is acceptable. I do have a question about this turning radius and the width of the driveway. I'm trying to look in the code of what the minimum driveway width.
14.
So this is 12.42, so they would need a variance for the driveway width.
Well, I don't know if there's a minimum, that's a maximum.
That's a maximum, yeah, no,
Oh.
that's a maximum.
I think there is a minimum also, right?
I think it's 9 feet.
It is 9 feet, okay. But, okay, right, okay. How would you, I still don't understand how a car is going to get into the first garage spot closest to the house.
Oh, I'm imagining the car going as far as it can up the driveway, then just backing in, you know.
I mean, that's an owner issue, it's not really, I mean.
Yeah, it's tight, there's no question it's tight. I mean, we angsted over this. In fact, you know, I was like, what are you doing this for, you know? But after they explained what the problem was, it became a little more clear to me too. We have to do the best we can, and still stay within the 40%. I can't make anything bigger, really. We're there, you know, so I have to shave somewhere, something, you know, somehow.
Can you address, I mean, I live in this area of town, and it's absolutely lovely on a lovely spring day, but there's always a million people in the park, right? And the traffic, people coming out of that entrance and going in is a nightmare on the weekends. And I'm just trying to figure out whether putting a driveway here where there's another, where like now cars are entering and exiting right next to where other cars are, that's going to make that more problematic. I mean, I have to drive this way every day to get home. Like, I live on Hathaway, so I go around. And I almost get hit by a car coming out of the park every time I'm driving to my house. And so I have a concern, and maybe it's not founded, and maybe you can address this, whether or not this is going to make the existing problem worse.
Ordinance requires that no curb cut be closer than 50 feet from the entrance to the park, and we're like 52 feet. I measured it myself, I stretched the ruler, and we're like 52 feet away. So we make it, as far as,
Whether or not it's compliant isn't my question. Could this potentially make the existing problem worse with the entering and exiting of the park directly next to that, and now we have another driveway right there? Or will it improve it? I don't know. I mean, that's what I'm trying to figure out.
Well, the driveway that is currently used will be reduced. If you look at the drawing, we're reducing this driveway because the part of that we're no longer using as a driveway, the curb cut will be reduced, and another will be put here. So we're giving up this and getting that. There's cars parked on either side of this, and by the way, that's a big reason we're doing this. My clients were adamant, it looks like Hoboken, during the summer especially. It looks like wall-to-wall cars. So I get a back. Doesn't everybody have this problem on this block then? Every single house has the problem you just described. So I'm not sure that we would be singled out.
But you would affect probably, and this may not be relevant to the application.
Right.
You might be eliminating a parking spot by doing that. Because you're still, I know you're lessening the current driveway, but not enough to allow, moving it back a bit, and then your new driveway is going to be wider. So, I mean,
that's true.
You're probably, on the plus side, you might be increasing to the lady's point, you may be actually increasing the sight line a little bit better. Maybe if I'm missing something, that somebody can't park as close to the existing park driveway as they can. You might actually improve the sight line. I don't know. I'd have to go over and sort of reorient myself. I frequent the park quite a bit, and I understand anybody who's living there. I live near a school. We all suffer from excess traffic and parking considerations. So
it's not even the parking I'm worried about. I'm worried about the potential for an accident.
Right.
Right. People coming, just how this affects that.
That's the 50.
For the positive or negative way.
Legitimate, but that's the 50 feet is supposed to be enough of sight line to take that into consideration.
That'd be the consensus of our engineer. He was quiet, but he did say it.
Thank you.
Okay, does anyone else have a question of the architect for this particular application?
I do. Still.
Okay. Is there anyone from the public who has a question of the architect on this particular application, on what he's testified to this evening? Okay, seeing none, is there another witness that would like to come?
If anybody has any questions of the homeowners,
did you want to clear up that situation about a lack of an easement? I think that somebody brought
That
up.
doesn't matter.
But it doesn't
It's
really
not
matter,
relevant
but-
to the.
Okay, it's not relevant to this.
Right.
Okay. That'd be the only.
So I just, as far as the, what beneficial versus non-beneficial, the only downside here really is that it's not allowed to have an accessory use, as a terrace cannot be an accessory use in this zone. Other than that, in every other respect, there are some dramatic improvements, and I hope the board takes that into consideration. That's all.
And I believe our zoning official concurred with that when they read the report, or whoever wrote the report. Basically, the only variance is the terrace. Okay.
And we had many conversations as to whether it was a deck or a terrace.
Yeah, okay.
I said it was a terrace.
And we don't define terrace in our code.
But we do have an ordinance against rooftop terraces. And because the primary use of it is a garage, therefore it's on the roof of the garage we turned it a rooftop terrace,
And not a rooftop deck.
and not a rooftop deck.
Certainly not a rooftop patio.
What's the difference
Or-
between
or
a deck and a
rooftop
terrace?
Or both bars.
Right, or a rooftop bar.
Right?
I just have one question before I sit down, and it's about impervious coverage. As I pointed out, there is some dispute as to, we're right on the line, and in the event that we need to steal a little bit more just to have the car better, or like I was pointed out, that the stairs would increase the amount of impervious coverage. Are there materials I can use that would, like, for example, the driveway pavers that are
The pervious pavers?
yes, things like that? Does that come into account?
Our professionals at Boswell generally are adverse to counting pervious pavers as pervious coverage. I can't say that it's okay, you can go over a little bit, because
No.
the board would have to give you a variance, which you haven't applied for. You could change and apply for a variance for pervious.
But is there any product or any strategy that would be acceptable such that we can reduce the amount of pervious coverage? That, in terms of material, is there a product or material or something to do with it? Or is it just yes and no? I guess that's what
You can check the DMP manual. When you go to the DMP manual, they have a series of products that you can.
that would be acceptable to,
Yeah.
okay, that's it.
Yeah, take a look at it.
Thank you.
And then it would be subject to Dr. Gonzalez's approval.
Sir.
Right.
Understood. Thank you.
Thank you. And you've done a really good job so far of hitting all the numbers. So you're at, let's see, 24.10, maximum 25, 39.2, maximum 40, 29.9, maximum 30. So we're not concerned that you won't be able to bring this right in where it should be. If there are no other people showing up, is there anyone from the public who would like to make a statement on this application? I get the same response out of you guys that I get out of these guys. Okay, seeing no one from the public making a statement, I would close the public portion of the applications and move to board deliberation.
A question for Kathleen. Can you tell the difference between a terrace and a deck?
There were a lot of discussions on this. What we determined was because there was a structure underneath it that had a primary use other than a deck, it was determined to be a terrace because it was up on the roof of another structure that had a different primary use, where a deck's use is just to be a deck.
So meaning that a deck does not have a primary or permanent structure underneath it?
Right.
Okay.
So this terrace is also serving in effect as a roof to the garage.
Yes.
Okay.
So that's why it's a rooftop terrace, and that's actually what is not allowed. That's the
Not
actual
allowed according
verbiage
to our-
used. Yeah.
I got you, okay. It makes sense, I understand. I can understand why you made the distinction. And conversely, if you call it a deck, they're over the height requirements for a deck, right?
Mm-hmm.
So you would be 6 to 1, half dozen of another. Okay.
Good talk.
I'll just say, and it might not be pertinent, I'm not a fan of the aesthetics of the project. I think it ruins the character of a very nice-looking home. I think it doesn't fit in with the character of the neighborhood, and whether or not it's pertinent to approving this application or not, I'm not a fan of it, unfortunately. And no disrespect, but I don't think it fits with the character of the neighborhood at all. So.
I have a concern where I do think it's going to be somewhat challenging to get in and out of this garage. And I have a feeling that there's going to be cars stacked at the back of this, or at least at the side of this property. And that is such a prominent view from Verona Park. There are some shrubs right there, but even if you chop them down at your property line, that's probably not enough to mask cars. That's a big concern for me. Although that doesn't have anything to do with the actual variance that's being asked for, but that's just a kind of a similar observation.
The aesthetics do matter because the variance has to do with a terrace on top of a structure, the new structure that is proposed. So it is not irrelevant and certainly a basis for someone to not be in favor if that's the way you're inclined to go. It may not carry the weight in your own mind, Christie. You might say, I don't like it, but I think they still carry the weight, or that could, ultimately be the decision maker for you.
Yeah, when I look at this application and, basically they're applying for a variance to be able to use a terrace deck with, we'll say terrace because that's what is violating. It's basically similar to what they currently have right now, and I don't see a big detriment. And I do like that some of the plants that are put in front of us have a reduction in impervious coverage. So I think that is it is a benefit when it comes to the turning radius with the cars. I mean, I do see that as kind of the homeowner issue, and I'm sure with their current configuration, there's already cars parked in the current shared driveway and not necessarily using the garage, since it is only a one-car garage as well. So I don't have any concerns about granting the variance for the rooftop terrace as it stands now.
I see that a hardship does exist for these people with regard to the sharing or the driveway on the right-hand side of their property. And I also think that aesthetically, if they were allowed to take that driveway out of there and put it on the left-hand side of the property, that aesthetically the house would be very pleasing. Not that it isn't right now, but I think it would be pleasant to have that. The tree should be removed, no doubt about that. And as far as the deck is concerned, there is a deck that exists there right now. I went over there today, took a look at that, and I also noticed that there was a lot of property on the left-hand side of the house that could take that we should take into consideration as far as a new driveway is concerned. So I have no feelings about granting this variance. I see that there is a necessity there, and I would certainly say yes to the variance. And as far as the deck is concerned, that seems to be the big issue. Since one exists there now, and they have made provisions for drainage to exist as far as this new deck is concerned, I would approve this variance request.
I think Dr. Reese sort of summed up my feelings about it as well. I'd like to hear just a little bit more as to why, about the aesthetics issue that Ms. Murphy Braddock brought. Can you elaborate a little bit more on your concerns on that?
Yeah, my concern is that right now you have a very pleasant looking deck, and it looks to me like when I look at, and I'm in the park every day, and then when I'm going to be looking at this, I'm going to be seeing what's going to look like a giant concrete slab. So if it looked different, I would have no problem with this application.
So your concern is the look as you're looking up from the park towards the back of the house?
Yeah, and as you enter
Okay,
the
no,
park.
I'm just trying to clarify.
And if the case, and the fact of the matter is the entire house is going to look like that when it's done, and the whole thing is going to be a giant, smooth stone house, I just think it's going to look odd.
Well, I just have to caution you about, again, what this board's job is. The property owners have the right to add a second floor. They have the right to change the exterior. They have the right to paint the house pink. So the reason for not voting to approve the application cannot be arbitrary, capricious, or unreasonable. It has to be based on the application that is before you. And I'm not saying that your reasons are not valid, that you don't think a terrace belongs on top of a structure. Now, they could build that garage without the terrace. The application is for the terrace, not for the garage, just so you know. I mean, so they could build that and it won't have the railings, but you'll still see that structure. So the consideration is, does the terrace, the use as a terrace, cross the line for you? Not does the structure cause you your issue?
Yeah, no, it does cross the line,
Okay.
because I think, I do. I think a railing on top of a slab is going to look strange.
Perfectly fine. I'm creating a record.
No,
That's all.
totally
Yeah,
understand,
okay.
totally understandable. And I know with other applications, occasionally the applicants will work with the board to create a more aesthetically pleasing design that might help, push, the weighing of it.
But we don't know, and it's not necessary for us to know, but we could envision this, that they would plant all kinds of beautiful shrubs around the garage that would go up to the deck that's on the top, and wouldn't be a concrete slab as you would dress it.
And sometimes we condition, sometimes we ask them if they're willing to be amenable as to having plantings of a certain type as a condition. We've done that in the past. That's just my feeling about it.
I think that's a good point. So this property in particular is super challenging because you're on the corner of one of the most famous parks, like anywhere around, right? So while I have sympathy for the site configuration itself, we also have to take that into account too. And that is a major, major factor, just to clarify that, because I think that's probably what you're alluding to,
We're known for our park.
Yeah.
But this town is known for its park. Yeah. And look, one of the reasons that we have land use, why we have these types of laws, is to make sure that when people build things in a town, the things that they're building generally fit with the character of a town, unless there is such a substantial hardship that we're willing to deviate from that. But I look at this as part and parcel. I think, that would be what I would want to see, is potentially a conditions requiring some coverage there to make it sort of blend in a little bit more with the neighborhood in that area.
Would the applicant be amenable to a condition of approval that included shrubbery around the garage?
Oh, certainly. A whole landscaping plan that identifies each species and how the spacing, the height. Yes, absolutely. If it's an aesthetic thing, I mean, had I known this would have been an issue, I would have done a full color 3D rendering of everything, so you can see exactly what's happening. I mean, it's kind of I was just addressing the variance.
Are you a landscape architect as well?
No, I'm not.
You're not?
No.
Okay. Mr. Chairman, again, my familiarity with the board, how does the board normally handle post-approval conditions for landscaping? Is it subject to, no, I mean,
We had a tradition. Unfortunately, they all disappeared in January, but we had 2 members assigned to review something like that.
with the authority?
With the authority to say it's okay. So
Okay, it's a little bit,
it worked.
it worked. It's so, I'm just trying to think, assuming that there is approval with this condition, Oswald's landscape architect approval?
You can ask them for her to check that too.
I mean, that's the only way conceivably I see that would be subject to the approval, because our ordinance does have native species requirements.
Yes.
But I think so that it can be professionally and not the opinion just of one board member, well, it will be then the Boswell, unless you want to do it. No, we can't. Yeah, right. I think it would be subject to the landscape review of Boswell.
Make it .39, is that what you're saying? No, that's what it would be on the report. If you add 39, subject to a landscape plan being approved by the Boswell landscape architect?
Yeah.
No, I'm not being facetious here. Just put that in there. You've already got a whole bunch that you've agreed to.
Right. Absolutely. Yeah.
Okay.
Lots of rhododendron.
Would that allay some of your concerns?
But it would just.
I would think that would be, would that ameliorate some of your?
It would ameliorate some of my concerns, yes.
It's a good thing we had Boswell here. Okay. I think we've heard from everybody on the board. At this point, I would entertain a motion. I believe I can safely entertain a motion to approve this application. If someone would wish to make that and someone would wish to second it.
I'll make a motion to approve the application variance for the terrace, subject to the conditions laid out in the Boswell report. And in addition to, it's in the report, adding a landscaping requirement.
Okay. Got that, Counselor?
I do.
All right. Do we have a second to that motion?
Second, man.
Thank you. We have a motion and a second. If we may have a roll call vote.
Dr. Reese,
Yes, I approve.
Mrs. Murphy Braddix,
Yes.
Mrs. DiBartolo,
No.
Mr. Ryan,
Yes.
Vice Chair Weston,
Yes.
Chair McGinley.
Yes. By my count, the motion passed. We will have a resolution prepared by our council that'll be considered and should be approved at our next meeting on June 13th. Don't do any construction before that. Good luck with it, and please make it acceptable to the public using the park.
I promise you, you will not be disappointed with how this place looks.
Thank you.
You don't take it like that. Thank you very much.
Thank you. Okay, folks, that means we go back on the agenda. Go back on the agenda because the last guy disappeared. Someplace here. There we go. Okay, the matter of application 2024-08, 48 Durrell Street. They have asked to be carried to the June 13th meeting. So,
They have had to go for stormwater management review. Boswell, in their report, deemed them incomplete due to stormwater.
okay, so
So they are going in for stormwater review with Boswell.
they're still incomplete.
Yes.
So we'll just anticipate they'll be one of our applications in June.
And there will be no further notice required.
Is there any reason to move to executive session this evening?
Yes, please.
General nature?
Follow-ups to our decisions.
Okay.
Administratively.
Okay.
Thank you.
Have a good evening, gentlemen.
Thank you.
Yeah.
What is the reason for the executive session that it can't be, that the topic cannot be, you mean executive private session, or do you mean you have something to discuss?
Yeah, it doesn't have to be private.
Oh,
Yeah.
okay. That's what I thought.
So we stay on the record?
We'll stay on the record, yes.
We're good. Okay. If you could lead us into that?
Sure.
So the agenda that, hold on.
Key portion of the discussion.
So therefore I can call you to tell them if it's like to the legislation, they will not be heard.
That's right.
Right. It's public, but I think Christie may want.
Can't do that. It has to be a topic.
What's the same exceptions for council?
Yeah, absolutely.
Personnel issues.
Litigation. While we're waiting, the key phrase I was looking for before, I couldn't find. My whole life. The benefits outweigh the detriments. Thank you.
That's it. That's it.
Will not adversely affect the intent. So but actually, I was trying to think of
How?
the benefits outweigh the detriments. What are you talking about?
Okay, are we good? Kathleen?
Yeah.
Good?
Well, that's true too.
There was a difference in operating procedures.
Absolutely. Yes.
Which I got used to.
I think we're ready to continue.
So several, I don't know, months, I don't know, I kind of lose track now. We had approved a vinyl fence on one of the properties in the forest section, and it has been completed. And I just thought that it might be a good idea to follow up with the board to see what our decisions do in real time. We have a pretty unique position because we impact the neighborhoods and our space and our utilization of the space. And it behooves us to kind of follow up and see exactly what our decisions do and how they impact these neighborhoods.
I agree wholeheartedly with some sort of follow-up, and we're supposed to have a pretty good idea on what we do, but if you go out and look at some of the things that we've approved, they'll make you stop and think. When we have a full board, it would be nice to, when we finish an application, I've given this some thought, when we finish an application, if somebody would volunteer to put that paperwork in their folder, and maybe in 6 months to a year when this is constructed, go out and look, and then bring it back to the board and just say, you know, we might have an application that we say, there was nothing significant about this, we can't imagine anything going wrong. Then again, we may have an application like tonight and say, look, after it's constructed, we'd really like to see that some opinion, we have some discussion on how we did with an application. I mean, right now, we just kind of.
Who is, it's a very good point, who is responsible for enforcing the conditions that have been approved on the application? It's sort of been, I guess, and we've had so many changes, I'll be diplomatic, in the engineering area, in the zoning area, in the building department area. I mean, over the time that, just in the year that I've been on this board, to say nothing of the 10 years that I was on the planning board before that, there's a lot of moving parts, except for Greg. But that's so.
From experience, like I can tell you that there is an establishment in town that as a condition of approval of their use variance, or maybe, no, it was a site plan perhaps, they agreed not to get deliveries after 10 o'clock in the morning or during school hours. I see deliveries every day, 3 o'clock. It's not on my street, so it's on Bloomfield Avenue. And it's not Frank Anthony's because they happen to be next door to my office. But so there are nobody following up on those conditions. And I don't know whose job it is or who would do it. But the idea behind that was because the schools, the truck, blocked the parents going in to pick up the kids from schools. And there's delivery trucks there every afternoon at 3 o'clock. So who's supposed to enforce that?
This is very interesting to me, Dan. In South Orange, when I sat on the board, the building inspector followed up with all of
With the conditions of the board?
Yeah.
And
I mean, I just
would this be,
assumed,
would this be a question for,
I just
Mr.
assumed
DiArco
that happened
basically
here.
is the chief executive officer for the town.
Right.
So it would have to be somebody, I would think, under his jurisdiction that would carry out the, the approvals. Greg, was that the reasonable?
That's true. I mean, first, the approvals are, handled by the construction office or the engineering office, the approvals that we were just discussing with this application, to make sure that, everything proceeds. But I think the question, what Christie's raising is the question, 6 months from now, how did we do? Not even compliance, but I think, like rating yourselves on, hey, this turned out nice, this didn't turn out nice. I think it was twofold, right, Christie?
Yeah,
Yeah.
I mean, this particular application just now, that is such a prominent spot. And we just impacted the lives of like all of Essex County. And we should hold ourselves accountable to whether or not that was the right decision.
So as far as the conditions of, not conditions of like when deliveries are going to happen, but as far as decisions about, like you're saying, the rooftop terrace or what have you. So when they submit to the building department, they have to, with their building application, submit a copy of the resolution that outlines all the conditions about what they are and are not allowed to do. There's just been a process implemented that at the end, there has to be an as-built submitted and then given back to me to make sure that what was agreed upon or set in their zoning or set in their resolution is actually what they've done.
And previously, an as-built wasn't required?
No.
Well, that's
No.
3/4 of the battle right there.
So that would take that. I mean, Dan and I have discussed, there have been other decisions that were made by previous zoning officers that, I have now found that are wrong or were incorrect at the time. There's what is that called? The Palmetto, which is a event space.
That crazy thing on next to Lakeside Deli there. Yeah.
That was approved by Mr. Epps, and that is actually not allowed in a mixed-use building. So it was approved with parking spaces that were previously approved for a yoga studio, with no time, no music limit, no anything, no where you're going to put your garbage, nothing. It was just approved, and so we had some issues. And when I looked it up, I said it should never have been allowed. But we don't really have much recourse on those type of things. But I will know when they're completed because I'll have to do the as-built if it's something like that. And I can absolutely, go back and say, okay, we're done, take a picture and give it back in.
Are you responsible for the as-built, the follow-up inspection? We're still talking about it, and you still want, they're going to come in and say, we've met all your requirements, okay?
That's the as-built.
That's as-built. But who actually verifies that? Do we just take them at their word?
No, so the building department basically will verify, I'll verify the actual as-built plan, but this is what we said they could do. But building will actually go out and do the final inspection.
Tommy's department, if I can put it, Tommy Jacobs'
Well,
department.
but final inspection just has to do with the actual building.
With the actual building.
It doesn't have to do with like impervious coverage and
No.
pavers and everything else.
Yes, no.
well,
On Ps you just did, we just had a house on 28 Ps where the as-built, they had to come out. And there was an issue about whether they had followed the approved plans with the impervious, and they had to recalculate. And, I was involved in representing the purchaser, and the town would give us a CO.
Yes.
And it because,
Right, so then that as-built had to come in and I had to compare it to
Right.
what was put in, what was approved, and what they've done.
Right.
Right, and building
Can you
made sure.
describe what the as-built, what is that? Is it a survey? Is it
Yes.
just a survey? So like a licensed surveyor kind of thing? So it's another,
It's a survey depicting everything, including HVAC, location, any pervious coverage, any impervious coverage, property lines, fences, additions,
so this is a post-construction
post-construction
survey to the
completion.
tune of another $1,500 or something, because that's how much surveys are.
Yeah, probably.
Yeah. I mean, okay, all right, just.
Which then becomes their current condition survey.
Right.
For their property that they would need forward anyway. But I mean, I think with the one with P's, I think I held it up for an air conditioning unit.
Right, because there was a
'Cause there
question of
was-
whether the air conditioning unit was new or not. But
Right.
I think also what Christie is suggesting, and Kathleen, maybe, this is something you could diary these things and do a 6-month, like on May 9th, you guys approved whatever they were on Park Avenue. And 6 months have gone by, if anybody wants to go by and see what it looks, just as a reminder, or if you have the jurisdiction to ask Jake, go take pictures so the zoning board can see it.
Yeah.
Something like that, like do a 6-month from approval, just to get a status. Right.
And I think, I'm interpreting, educationally, we'd like to know, for instance, like the fence. We all go and look at the fence and say, wow, that probably wasn't a good idea that we had to say okay. Or when we really approved the off-street deliveries of vehicles, we probably should have realized that that wasn't going to happen. And now it becomes enforcement issues.
Right.
And following up, on enforcement issues, maybe we can eliminate some of the enforcement issues if we become alerted to things like that and we discuss them and take them in that light at our meetings.
So I actually have to go out tomorrow to look at Enterprise Rent-A-Car. There's a problem with where they're entering, so I have to, get the resolution now and go back to see what was allowed and what they're doing. And evidently it is two totally different things.
And how many cars they can put on the lot.
Right.
Which one?
It's Enterprise Rent-A-Car.
Oh, okay.
Yeah.
Yeah, I hope that's where part of that was headed, was one, to make sure we have a system in place that confirms that all the things that we approve show up in the final plans. And secondly, gives us an opportunity to look at it and say, well, they did everything we said.
Unfortunately.
That's it. And it looks like we made quite a camel.
And as a side note, Mr. Timpanaro is back from Florida and is going to be deciding what he's going to do about either, appealing or,
Is that the Fairview there?
that's the two garages,
The two
yes.
garages.
Yeah, so he is back. And much happier than when he left this room.
Son does everyone's good.
Right, just to decide, how far along are they with the master plan since you're, we're working off the old one?
Not far.
Not far?
No.
They're not far along?
We're not far along.
So
We don't have to learn any
stuck
new
with this
rules.
ordinance package for a while, in your opinion?
Yes.
Okay.
Yes. No, I don't believe that we're far along, no.
So we don't have to learn any new rules.
Because in line with, lessons learned, I'm going to use that famous expression, just for a bit of ancient history. I came on the council I have to take partial responsibility for some of this disaster, because I was sworn into the council on May of 2011 in a special election. The mayor at the time, I will not name her, but pleaded with me that this thing that's been so bandied about, talked about, whatever, please vote yes. And
We never finished it. It was never finished. It was voted on before they wouldn't let us finish it.
we'll let you finish it.
We
They wanted
had-
something in place.
We had 3 more edits to go,
And
and
they decided to put it in.
because we all had, well, just so everybody knows, when we did the zoning ordinance, Jim Held, who was the town engineer, me, Jason Kastler, Tommy Jacobson, and one other person, who we met every week, 2 hours every Wednesday morning or whatever, and we started from start to finish to write the zoning code. And, we were writing and writing and writing. Then finally they said, we got to vote on it. And we said, we're not finished, because we never cross-referenced to make sure that everything was consistent. And that was going to be the next step, and then do one final edit. Nope.
Which, by the way, which also should be compared against the building code.
I'm sorry?
Which also should be compared against the building code, because there's some contradictions.
Well, that's what, I mean, we never,
In the intervening 14 years now, I mean, we have discovered, well, you know, numerous inconsistencies.
I could have told you the next day that there were some inconsistencies.
Okay, I just think it helps to put some context as to what we're dealing with.
Right.
I guess Dan and I have been the only two that have been involved in this for ad nauseam, but, you know.
Isn't there a requirement that it has to be done within 10 years or something?
Well, that's what happened.
That's what happened. They probably were, I'm just
Yeah,
guessing.
not the zoning code.
They probably were pressured by somebody to.
Just
Not the zoning code, that's
the master plan. So
And then there has to be a re-examination report, but
we're going to slide into the next master plan
Some homework.
and have a set of zoning ordinances ready to go from the previous. Okay, is that,
Is that it, Christine?
Christine, where's the fence that started this conversation?
It's on the corner of South Prospect and Pease. No, I'm sorry. Yeah, Pease.
South
Yep.
Prospect and Pease?
which corner?
The northeast corner.
I was wondering how that got there.
Yep.
Would it look as bad if it was a different material?
Now,
Well, this is what I'm talking about with
I
aesthetics.
don't-
I don't think aesthetics are arbitrary and capricious. I'm going to tell you right now, I do not think so, council. They are not.
You can't legislate taste.
you know.
They are.
We can discuss these things ad nauseum and come to an informal agreement, but at some point, we might want to consider drafting a letter as a board to the town manager who is responsible for enforcing it, and put our concerns in writing. Because Dan calling him and suggesting that we do this and that and the other thing, everybody has different recollections. I can just tell you of conversations. It doesn't have to be a nasty memo. Just say we'd like to be informed, we've had this discussion, we'd like to be informed when as-built,
Well, we have that.
yeah, I want it on record, Greg, that's all. Because Mr. DiArco keeps telling me he's gone in another year. He's on a 3-year plan and he's out of there. He's told me that on 15 occasions. So basically, and no, that's, when you change.
That's actually more notice than anybody on the zoning
When you
board.
change administrations, the new administration always blames the prior administration for all the mistakes. So I'm just throwing that out, not for tonight, throwing it out there for the next meeting. Just think about it. If you want to, consider drafting a concerns memo to the town manager. This has come up, please advise us, formally when the application has been totally satisfied.
Kevin, if it weren't for those 67 people who voted for a particular other candidate, you and I would have been on the council together. Yeah. It was close. It was close.
Mr. Chairman, can I make a motion that we adjourn?
We'll accept that.
No, we never went into executive session.
We never went into.
There
was no reason to go in.
Okay.
Greg Kabosh.
A motion to adjourn.
Accepted.
So Kathleen, we can keep the 12 Linwood paperwork and the Bloomfield Ave paperwork.
We have a large pile of keys. That means we're not moving forward on anything.
The other one, do you want an electronic signature on this?